Welcome everyone to the session on sworn documents and how to use them. Before we start, I want to acknowledge that I am working on the shared territories of the Musqueam, Squamish, and Tsleil-Waututh peoples who have stewarded these lands for many years, and that we hope to work productively with them in the future. Because I'm interested in getting better at territorial acknowledgements and certainly understanding the issues involved in them, I put a link in the chat that sets out all the different territories in the province. It's an interactive map of the different nations in BC. So in case anybody's interested, that is there for just completely separate reference. But focusing on the session today, I want to introduce Odette Dempsey-Caputo, who is the staff lawyer at the Kamloops E. Fry Poverty Law Clinic. She's been there, I think, I'm right in saying almost a year probably, but I'll let Odette clarify that if I've got that wrong. She has a long background working in legal aid and working with legal aid clinics, has worked for 12 years as a lawyer in BC. I think I'll leave the rest to you, Odette, to introduce yourself in more if you want, or start your presentation. As we say all the time, people, we will look for the questions in the Q&A. And I'll try and, if they're pertinent at the time, I'll flag them and ask Odette then. Otherwise, we'll probably hold questions to the end. I think we're good to go.
And thank you. I appreciate that. I just want to say hello to everyone. And I am joining you from Kamloops, British Columbia. I want to just acknowledge that our office, the Elizabeth Fry Legal Clinic, is on the traditional and ancestral and unceded homelands of the Secwepemc Nation. So as stated, I've been a lawyer for about 12 years. I work at the Kamloops and Elizabeth Fry district, and they host the Elizabeth Fry Legal Clinic, which began in December of 2019, so just about a year. So just to go over what we'll be covering, we are going to talk about what sworn documents are, when you should use them, why you should use them, and who you should use them for, and then we'll go into how you create them. And just for a quick poll, we do have a poll here if you could participate in that, and it's just who here has used a sworn document before. Just give you a minute or two to answer that. So we seem to have about 50% of us have used sworn documents before. So that's a good sign. And just as we go along, just to help you out here. So what is a sworn document? So there's two types of sworn documents that we would generally use, and that's one of an affidavit and one that we call a statutory declaration. Now, the difference between these two documents is the affidavit is primarily used when you have a court process going on. So that would be used in a family law or a civil law proceeding. You would have a file number, you would have a court registry. They are both sworn documents, and by sworn, we mean they are similar to giving evidence in court. It would be considered, if you lied on them, similar to lying in court. The statutory declaration is very similar to an affidavit, except for it's outside of the court process. So you're not going to have that file registry number. You may use it for all kinds of different reasons. So when do you want to use a sworn document? Now, I'd like to put to you that sworn documents are like a tool. You can use them for many different reasons and many different ways. So think outside of the box when you want to use a stat dec or an affidavit. And stat dec is what we kind of generally refer to as statutory declaration. We short it to a stat dec if you ever hear anyone use that term. So I would like to say anytime you need to give evidence, especially if you're able to give evidence in writing, if you are required to do so orally, then you're not going to be able to do that through a stat dec or an affidavit. But as you can see here, you can use it for benefit applications. So these could be PWD, it could be CPP, it could be income assistant if you're wanting to give some evidence. For tribunals, residential tenancy branch, great place to use stat declarations in. Employment standards, WCB. Same thing with human rights. Now, human rights, you're not always going to be able to use them, but we do use them quite a bit in human rights. So it's going to depend on how the tribunal has asked you to present your evidence. As well, you might use them for an ID application, medical business benefits, and I put witnesses here. So if you have a time that you were trying to give some kind of evidence and you have somebody who's not attending the hearing, you may want to try to give their evidence through a statutory declaration. So then the next question is why? Why would you want to use a statutory declaration? I've kind of alluded to some of that. But first off, and I kind of have 4 little bubbles here, so efficiency. So one of the reasons why you might want to use a sworn document is you can really narrow down what the client is trying to say. It also means that you don't have to reiterate everything if you're before a tribunal, or if you have some kind of hearing. Generally you want to refer to the affidavit or statutory declaration, but it does help in efficiency because that evidence is before. So that's where you kind of go into the familiarity. A lot of these bubbles are connected to each other. So familiarity can be 2 fronts. It can be for yourself. You will find when you are drafting a sworn document or a stat dec that you really get a handle on what your evidence is and what you want to say. It also makes it much easier for the person who will be reviewing the evidence. They are then familiar with it. So if you were then to give oral submissions, they already have an idea of what's going on. They understand what's going on. And so that gives them some familiarity of kind of what's going on. And then for clarity, when you do something in a stat dec or an affidavit, you're able to tell the story in a consistent and clear way versus kind of jumping all over the place. It allows it to be done in a chronological order. It allows you to be able to say it in a way that a person's going to be able to understand it. It can be extremely helpful if you have a more complex situation that going on that you need to explain in a more detailed way. And then I'm going to say it helps clients. And I'll cover that a little bit more when we talk about who we want to do these for. But I think that a lot of times with clients, it can relieve a lot of their anxiety when you present their evidence in this way. So that's what I'm going to say here, who. So as we all know, when we're dealing in poverty law or in the areas that we work in, our clients come in all shapes and forms, and they have a lot of different backgrounds. So when we're looking at a client and we're trying to decide who do we want to do this evidence for. So clients. So there's many different reasons or different types of clients that you would want to present their evidence in a sworn document. I've listed numerous ones here. Mental health issues, that can be huge. As I discussed, clients who have anxiety or other mental health issues, it can make it a lot easier for them to get their evidence out. You may have a client that likes to talk too much. This can be particularly helpful in a residential tenancy branch where the client basically likes to talk themselves out of what they were saying. They might agree to the other side when something's presented to them, or tell a story and misrepresent it in a way. So we always say that when you're asked a question, you just want to answer the question that was given. Don't go on a long story. And we know that a lot of our clients do this. We also, you'll come across clients that have trouble with chronology. So the client tends to be someone who, starts in 2011, and then the next thing you know, they're in 2003, and then the next moment they're in 2014. Using a sworn document can really lay that out in a proper chronological order, which allows whatever tribunal or place you're sending the stat dec. You can send a stat dec with a letter, even if you were sending one to, let's say they've been denied for something, but you're just trying to send a letter hoping you don't have to get any kind of judicial review or go through the review process. You may send a sworn document then as well. So that can help with chronology. Brain injury, a lot of times clients that have brain injuries, one day they might be doing well, the next day they might not. When you have a hearing or something else going on like that, it can be very difficult for them. You might not know what kind of state they're going to be in, so that could be another one. Processing disorder. So there's lots of different types of processing disorders. The sworn document can be a way where it takes away a lot of the stress and the anxiety and helps them present their evidence in a more proper way. Systematic discrimination. I think that sworn documents can also help in this kind of situation as well. Especially if there's power imbalance between the person that might be reviewing or the person on the other side and your client. I put loud here. I've had a lot of clients, especially maybe bigger men that have strong voices that can come across as being very aggressive, even though they're not intending to. It's just the way they speak. But because of their demeanor, they come across as being more aggressive than they are. So sworn document can help that. And then I'm going to say untrusting. So if you have a client that's very untrusting of things, this can also be helpful for them. Now, saying that, you need to realize that some clients will be nervous about having a sworn document because they're nervous about anything putting down on paper. So you do need to be aware of that as well. I've had a client that, we were trying to get the story out. The client never really did get the story out until we got that affidavit down, the sworn document down. They couldn't explain what had happened to them. They couldn't explain what the harassment was. They would just say, oh, I've been harassed. I've been discriminated against. And being able to write that down on paper can also be very helpful. So also with the processing disorder, you also run across clients who will be telling you a story, but if they get asked a question, they have to restart the whole story again. This can be quite difficult if you're in a tribunal or you're in some kind of other hearing where a sworn document can help that evidence to be in a more chronological way. I'm also going to say when it's not a client and you're looking for a witness, so you may decide to use it if it's a residential tenancy branch and for some reason someone can't attend that hearing, you may get them to do a sworn document instead of doing it in a way that's trying to have them attend the hearing. Now, it's not always accepted. So the bigger thing around this is how. How do you write a sworn document? So I did provide you some examples of these in the materials for this course. I'll also be providing you with these slides as well. So just to give you an example of the difference between the statutory declaration and the affidavit, if you look over here, the statutory declaration, the biggest difference is going to be this top part here and right here. So those are going to be the big differences. So you can see up here, this is an insurance claim. Maybe they're sending a letter to the insurance company trying to explain what happened. By sending it in a sworn document, because it's similar to giving testimony in court, it can be very helpful. The insurance company might be more accepting of it because it is a sworn document versus just putting out what happened in a letter. It gives it more teeth. And then this is your affidavit where you see you have a file number and you have a registry right there. So just to go over a couple of the terms, we have our affiant or declarant, and in this case, that is Donald Duck, and it's the person who's declaring it. So this is the person that is swearing to the sworn document. This might be a witness or it might be a client. And style of cause, if you've done any kind of civil proceedings, you'll see this term used a lot. So the style of cause is this right here. So we're talking about this top part right here. You're going to put that in most documents, and this will be the same no matter what document in kind of the civil court. So for the introduction with one of these, you want to include the person's name. So you see we have Donald Duck here. And the reason why this is in brackets right here and in bold, generally with a name, you don't have to, we call that defining it. You'll see down here, we define the vase. So whenever we say the vase, we're talking about this particular vase that got broke. But if you see up here, we've defined Donald Duck because it's not really his name, right? That's what he's known as. So we've defined it as Donald Duck. And same down you see here, if we were just using Hubert, we wouldn't have to put definition here. We would just say Hubert, but here we've put Huey. So you're going to include that with the name first. And then you're going to include the occupation. So in this case, Donald Duck is a sailor. And you have here where they live. So you have their street and their city. Now, if you have a situation where the client is not wanting the other side to know where they live, you might just put the city down, but really you should be putting the street address, or you can use another address, maybe your organization or another one there. You're going to say what province it is. And then right here says swear or affirm. So you don't have to swear it. You can affirm it. So you can use either one. Swearing is generally on the Bible or another situation. So affirming is what most people will be do. And that's just affirming that you are calling it the truth. It doesn't matter in court. We still consider this to be, you're not allowed to lie on this, whether you affirm it or swear it. And then the connection to the issue. And what this means is, if you see here, it says, I am the claimant, and that's why they have personal knowledge in it. And then up here you have, I am the insured. So what you're doing is you're having the client or the witness explain what their relationship to the issue is. So let's say it was a residential tenancy branch and it was a neighbor that was giving this evidence, then you would say, I am the neighbor of Donald Duck. That's another way you can do it. So you just want to kind of set out all those things so we know who and where this person is. So we're identifying who this person is instead of just having, some random name on there. Okay, so then we have sworn, this is the end of the affidavit or stat dec. This will look similar, whether it's an affidavit or it's a statutory declaration. So at the end, you're going to have sworn or affirmed, and you have to put before. And the me is, this is the commissioner. So a commissioner in BC, all lawyers are notaries and commissioners. So we can swear those documents. And if you recall, Andrea and Bryson of RISE explained in the Canada Child Benefit webinar how different advocates can become a commissioner. Is there a question?
Yeah, that's why I turned up. Yeah, there is. The question was what happens if a person changes their address after the sworn declaration is sent?
So you don't need to do anything because it's a matter of identifying the person at the time of the date. So it's similar to when you're drafting a will, you will say, yeah, I lived in the city, but if you move to a different city, it doesn't change the document. It's just identifying you that on that date, you're at that address. Now, if you're going to court, it might be helpful to the court if it's relevant to the situation to point out. So let's say you made a mistake in an affidavit, you're required when you appear at that tribunal or that court to say what's wrong in the stat dec. Sometimes that happens. The client's supposed to identify these things if there's something wrong, but you can just point it out right away. So it won't change. It doesn't matter if their address changes. As long as it's the correct address at the time that they swore it. And then, so yeah, as I was saying, you can become a commissioner. And if I think Andrea Bryson, she put up there how you could do so right in the PovNet discussions. Anyways, so the commissioner must, and this is important for you to know so it's being done right, but must print their name below their signature. So right here below this part, the commissioner will print their name and they'll generally put their address in there as well so they can be identified. Often lawyers will use ink stamps. So we have this little stamp and we just stamp it and it explains our name in print, and then it says that we are a lawyer, and it also says our address. And probably the mistake that a lot of people make is you cannot have your client sign here and then the commissioner sign here if they're not in the same room. This all has to be signed at the same time. So this person here, Donald Duck, has to sign it saying that it's the truth, and then the commissioner signs over here. If you showed up to my office and you have this signed already, I can't sign this because I need to actually see you sign it. Also, you should remind your client to bring ID. The person who is signing over here needs to see the client's ID or the witness's ID so we know that who's signing it is actually the person who it says it is. So that's something that people don't often realize. And this must, and we're going to talk about exhibits, but the commissioner must sign in front of the affiant, including exhibits. So all of this is signed at the same time. And that is probably one of the biggest mistakes people make when they are signing affidavits. So exhibits. So exhibits included an example here. So exhibits are documents that you attach to the affidavit, so or stat dec. Generally, not all stat decs have them. There's some school of thought that stat decs shouldn't have them. I always include exhibits. I think it's a sworn document. It's great to do it. Exhibits can be all kinds of things. They can be photos, they can be text messages, they can be receipts. They also, by attaching them as exhibits, let's say you're going to the residential tenancy branch, it allows that the tribunal member to really look at it and understand how the evidence fits into the story of the client or the story of that witness. So it's really great at organizing the evidence. When you have an exhibit, you first, and you can see over here, you first mention it in the actual sworn document. So you would say attached to this affidavit or attached to the statutory declaration, and marked as Exhibit A is a photo of the smashed vase. Then at the end, you will have that photo. And there's this nice little stamp here that the commissioner will have. It's helpful if you write that in. Don't write in the date until it's actually sworn, because that can change. So you leave that part blank, but you'd fill this out and then the commissioner will sign that. And the client, all of these things have to be attached together. So it's not like you can add the exhibits later. They all have to be done at the same time. So you just need to be aware of that everything has to be done at the same time, and it's all together as one big document, because you're swearing that these are all these things. So these are designed to make sure that this exhibit that you talked about over here in the sworn document is the same one. So that's why you have that right here. So nobody can like switch it out for a different kind of exhibit. And these are arranged in alphabetical order. So it's Exhibit A, then it's Exhibit B. So you talk about them in alphabetical order in the sworn document, and then you will present them at the end of the sworn document. So that's after, these exhibits all come after this page. So after this page, then you have this exhibit. And then this exhibit, they will also be in alphabetical order, starting with A till the last one. They come in order in that sworn document. Now, this is called what we call a backer. So a backer is only really relevant if you're doing an affidavit. So you'll see here, we have our style of cause, once again, and then the name of submitter. So this, in this case, it's a Feather Firecracker, Firecracker, and then you have their address. So here's your address right here. If it's a law firm, they're going to put their law firm name on there, telephone and fax number. So when you put this stuff down here, this is actually how someone could serve this person afterwards. So they could serve them by fax, because there's a fax number here, and what the document is. And you have it right here. It's the first affidavit of Donald Duck, with the whole name written out. Now you'll notice that this is in landscape form, not in, not flipped the other way. The reason that is this backer actually faces out, almost like the back of a book. So it's actually facing out, so that when they're rifling through the files at court, they can see right away that this is the document, the first affidavit. So you can get tons of different documents, different affidavits. There might be different applications, and it makes it a lot easier when you have it set up this way. So if you ever hear somebody say this needs to be a backer, this is what they're looking for. So this is just kind of my to-do and don't list. So you do need to number the paragraphs. So when you look at the example that I provided you, each paragraph is numbered. You also have to number the pages. Now that includes the exhibits. So I generally will start, one at that first page, and then, if it's 4 pages long, then the next exhibit might be page 5. This not only is a requirement when you're filing things in court, but it also makes it a lot easier for referring to something. So if you have something like 10 exhibits, it's great to say turn to Exhibit D, but it's easier to say, it's hard for them to find it. If you say turn to page 20, Exhibit D, they're going to be able to flip through that quite fast. Generally, the paragraph numbers are on the bottom right-hand corner, the page numbers, and then each paragraph, so each thing is also numbered. So on here, do use exhibits. use them, attach them. Like I said before, it really helps the organization of the evidence, and use headings. So in my examples that I gave you, I didn't use headings, but if you had maybe a 10-page affidavit, you really want to use those headings, because what you're doing is you're allowing the person who's reading it to be able to find the evidence that they're looking for. So if you're talking about, if it was family law, you might be talking about child support, you're going to flip to that. If you're RTB and you're talking about, pictures of the house, the rental, you're going to flip to that page that talks about those pictures. So it's just a really good way to use it. And I'm just going to point out that the reason why I have a picture of a book on this slide is your sworn document. Think of it as a book. It's like a book. You're telling the story. You're telling the story of the client. So you want to make it an easy read. That's what all of these do's are for, so that whoever's reading the sworn document can get through the evidence easily, they understand the evidence easily, and they have a better understanding of what's going on. These can make a big difference between whether you win or lose something, or if you're sending it attached to a letter, whether the person's going to accept what you're asking. If you've got, if you're at RTB and your evidence is all nicely worked out and it explains everything, and then the other person's evidence is very mumble jumble, it makes it, they're more likely to accept your evidence than the other person's evidence, because they kind of understand what's going on. This should be the avoid and/or that should be more in a don't. So don't do that. It's important, like I said, it's similar when you're writing a book. Know why are you drafting it? What is your purpose for this affidavit or stat deck? You really want to make sure you know that, so that when you're drafting it in a way that is going to be the most efficient. Know who is signing it. So is it your client? Is it the witness? Who is telling this story? You want to write in first person. You may have the odd client that talks in the third person. You won't get a lot of them. Regardless, you're always writing the first person. It's I, not Donald Duck. That shows whoever's reading it that it's actually that person's evidence. That's where we come down to here. Use the person's own language. If you've ever read a book, you can tell different authors by the style of their reading. It's the same for us when we talk. So you really want to get your clients the way they speak. That way, if they're, it's more clear that this evidence is coming from them and not from you. Use a person's name, not, she, he, ze, or they. You want to make sure that using the person's name, it makes it more clear. And I'll have an example later on of kind of where that falls. As I said, you're telling a story. You want to set it out in chronological order. You want to use language people can understand. You don't want those $10 words. I always say that 80-90% of the population should always be able to understand what you're trying to say. You want to keep it simple. Don't repeat what you're saying over and over again. Get the evidence, make it clear, make it as easy as you can to the person that you're trying to get to accept this evidence. Check for spelling, logic, and facts. So make sure things make sense. If you're saying something happened on Saturday, don't then start talking about how it happened on Monday. Or if it went over a couple of days, you need to describe why did it go over a couple of days, what happened in those. So you really want to make sure that it makes sense, that you have just facts, and that you're checking for spelling. So you don't want to get into a lot of assumptions in there. That's not what you're looking for. So do not over exaggerate in your affidavit. That's using intensifiers. It's not always or never or, extremely. You want to take all those out. The more straightforward you are in a sworn document, the more likely it is to be accepted as true evidence. You're not going to include conclusions or arguments. This isn't the place. The sworn document and affidavit are meant to get the facts out. That's what these are for. You're getting the facts out. It's not time to make submissions. It's not time to try to argue your case. Like I said, do not repeat yourself. Do not include information that is not relevant. If it has nothing to do with what you're trying to get across to the tribunal or to the organization, don't include it. Do not use hearsay. And you can say, I said, don't attach letters from witnesses. Those two are connected. So hearsay is when the client or the person who is swearing the document doesn't have that knowledge themselves. So you don't want things like the neighbor said, or I read somewhere else that this is the case. Those are all hearsay. I don't personally know that. I didn't see that happen. So that's where you kind of want to be careful. There's a lot of exceptions to hearsay. It's a very complex concept that a lot of law students struggle with. But the big thing is make sure you're writing what the person actually knows, not what's been told to them. And that's why we don't use letters attached from witnesses. I see this all the time in tribunals, especially the residential tenancy branch. You'll see it all the time. You want to avoid those. If you're going to put that evidence in, if the person cannot attend the hearing, better to put it in a sworn document directly from that person than to attach a letter. Don't use legalese or legal concepts. So be very careful of using things like negligence. Negligence is a legal concept. It's something that people tend to use a lot. They'll say, oh, you were negligent, but there's a very specific test for negligence. A lot of these terms that we use, that's how it is. So you aren't going to use negligence. Lawyers shouldn't be using it in their sworn documents either. You're going to show the facts that may lead to the conclusion that it's negligence, but you're not going to use the term negligence. So I'm getting through this quite fast, so I'll be able to take lots of questions afterwards. But if you could grab a pen and a paper, and we're just going to do a couple of practices. So what I'm going to do is I'm going to give you a sentence. I'll give you about 5 minutes or maybe 4 minutes to see if you can point out with all the do's and the don'ts that I put out there to just identify what you see is wrong with this sentence if it was in an affidavit or a sworn document. And I'm not going to call on you to say it, it's just for your own personal thing, and then we'll go over what those are. So the first one is, so what is wrong with this? It says, Huey was mad at Dewey and wanted to attack him. Louis told me that they had been fighting all day. So I'm just going to give you about 4 minutes to kind of look at that and try to list points. There's about 5 different points that I found that is wrong with this sentence. And if there's any questions, feel free to ask them at this time too, and I can answer them while we're doing this.
There was a question. It was, can you hear me? Yeah, you can. When is it not advisable to use an affidavit?
So if the tribunal or the organization says that you need to give that orally, then you are not going to use a sworn document. If your client is paranoid about putting things down on paper, that might be another time that you wouldn't use a sworn document. So outside of that, I would say that most times a sworn document is going to be appropriate, even if you have to re-speak to that evidence afterwards when you're in the tribunal or you're in that hearing or you're on that phone call to, Canada Revenue Agency. You can still re-speak to that or have the client speak to it, but at least the evidence is there in a concrete way, in a chronological way. Let's give you a couple more minutes.
Oh, sorry, what am I doing? Yeah, sorry. I guess people could put it in the chat if you ever want them to do that too, hey?
Yeah.
You might be shy.
Should add, one of the reasons why I said practice, practice, practice is that we all make mistakes. Lawyers still make mistakes. We appear before judges all the time, even though we've been doing this lots and the judges get mad how we've drafted these. The more you practice it and the more you do it, the better you'll get at it. There's also great resources out there. I will put them in in a document for you guys as well. But Legal Aid, the LSS website, has really good step-by-step, and it is for drafting affidavits, and it is geared towards family law. But a lot of these rules are the same, regardless of where you are using your sworn documents. So I highly recommend that you look at those sites. The Supreme Court of British Columbia, once again, they have on their website, they have a document that talks about sworn documents and affidavits. Using their steps and using them as examples can be really useful. I highly recommend looking at it. There's a lot of resources out there if you go searching for them. But if you do, make sure you're using a British Columbia source. Different places have different things. For example, not every province are lawyers automatically commissioners. So you just want to be aware. Don't ask me which ones. I'm not positive on which ones are which, but not all of them are that way. So it's even finding that commissioner. I know a lot of police officers are commissioners. There's a lot of different people who can swear these documents for you, be the person that is the commissioner for that. So that's something to keep in mind. But just if you're looking for those tips, that is one thing to do. So I'll just go to the next page. So what do we have?
Oh, sorry. Just so you know, somebody leapt in and said that hearsay, as even before they saw the slide, they said hearsay.
So just to go over this, so you say used conclusions. So Huey was mad and wanted to attack him. So you have Louis was mad right here. You can't say what somebody else is. You are not the person that was mad. So you can't say Huey was mad. You can say Huey was yelling. Huey was hitting things. Huey was, clenching his fists. You can use those kinds of terms to describe what's happening, but you shouldn't say the person was mad because you don't know. Unless the person said, I am mad, then you would have put that as Huey said he was mad, and you put that in quotations. Wanted to attack him. How do you know that person wanted to attack them? You can't, there again, that's jumping to conclusion. You want to describe what happened without coming to the conclusion that that was a desire that that person wanted. So it's like Louis, hearsay, Louis told me, right in there. Louis told me that they had been fighting all day. This is hearsay right there. You can't describe what someone else told you. You can only describe what you were told. There are exceptions to this and that you might be able to do, but like I said, it's complex. I'm not generally going to get into it. You might only, the one exception that would be easy to explain here is if you were to say, Louis told me they had been fighting all day, that's why I did X, Y, Z. Then that evidence is saying what you did from what was told to you. It's not that you're swearing that that's what they were doing. You're not affirming that they had been fighting all day. What you're affirming is somebody told you they had been fighting all day. And because you were told that, you reacted in a certain way. That's fine. But to just say they had been fighting all day, someone else telling you, you can't use that as evidence. It's also not relevant. In this particular situation, they were fighting, they knocked over a vase, and the vase broke. It's not relevant to the vase breaking that they had been fighting all day, so you shouldn't even need to include that anyways. The other thing is it's one big paragraph. So in this case, you would say one sentence would be one, and then this would be another one. So you're going to have each kind of sentence is its own paragraph. There may be situations where you don't do that, but generally that's a good rule to follow. They also used Huey, instead of Huey and Dewey, they put they. So who's they? Was it Louis and Dewey? Was it Dewey and Huey? That's why you want to avoid those and use names. We don't know who they is. This is a sworn document. You're not allowed to jump to conclusions. The person who's reading it's not allowed to jump to conclusions. You really want to make sure that you are covering that so that you are explaining who it was. So Louis told me, now you wouldn't be saying told me, you could say, I saw that Huey and Dewey had been fighting all day. You could say something like that, and you're going to describe what did you see, but you're not going to just use they because it's just too vague. We don't know what's going on. So we're going to do one more. So here's the next one. Huey is always hitting Dewey. The assault on Dewey did not come with Huey's consent. Huey, Dewey, and Louie meant to break the vase. Huey, Dewey, and Louie never liked the vase. So I'm going to give you a few minutes to look at that and see if you can come up with what is wrong. I should point out there's going to be ones that I missed, even that would have mistakes on here. Okay, so we're just going to look at this. So the first one here, used an intensifier. So we have always. Huey is always hitting Dewey. Why? Why? We don't need the always there. He isn't always hitting him. He's not constantly hitting him. He might hit him a lot, but he's not always hitting him. I'd also say there's not really a relevancy here. Why does it matter that he's always hitting Dewey? Then the second one on here is used legalese. The second paragraph, we're talking about assault and consent. Those are two things that people will use a lot in general language, but they are things that have very strong legal concepts around them. Consent, there's a lot of law behind what is considered consent, implied consent, and then there's that term assault. Generally, you know, that's a conclusion as well as using some legalese. Both of those kind of legalese things are a bit of a conclusion there because you do have those terms back there. Other legalese would be wherewith, therefore, all of those extra words that you see lawyers using a lot. Not only does it not allow the sworn document to flow as nicely, it's not really relevant, it's not really needed, and sometimes you are using a conclusion by using that. Then there's a lot of conclusions here. Meant to, never liked. They meant to break the vase. You can't jump to that conclusion. You don't know. Did they mean to break the vase? Was it an accident? That's really what this whole thing is about. So you're coming to conclusion there. You're trying to sway. It's argumentative in a lot of ways too. That's another thing. You don't want to be argumentative. You're not trying to make your argument here. You're sticking to the facts. The fact is they broke the vase. Whether they meant to or not, it's not a fact. Like I said, unless they specifically said, I meant to break the vase, you could add that in there. But even then, that's not necessarily means that they meant to. You would just say they said that they meant to. It's up to the person who's reading this evidence to really come to that conclusion. And it's the same with Huey, Dewey, and Louie never liked the vase. You're kind of putting motive in there. You wouldn't say they never liked the vase. You might say Huey, the last time Huey was at my house, Huey made a comment about how ugly the vase was. That's what you would put in there versus. So really what you're trying to do is get the evidence out there that allows the person reading the sworn document to come to the conclusion. You do not want to bring up that conclusion yourself or the person who's swearing that document themselves. So that's what you really need to watch out for there. You're describing what happened, not coming to those conclusions or, using the legalese there or becoming argumentative. And I do appreciate it. I went through this quite fast today. So if anybody has questions, I'll for sure take them at this time. You can see my email there. Feel free to reach out and ask me any questions. Anything you want to ask about that, I'll put up some resources on the line. And I also wanted to just thank Legal Aid BC and the Law Foundation for putting this training on. I also would like to thank Louise and who's the facilitator and Sarah, who is the tech support today. So faulting any questions, that is the conclusion of my my presentation.
There is one question here in the Q&A. Someone's asking, is it okay to say that Huey appeared agitated? So no, you could say, you could, if you feel like you need to say the person appeared agitated, you would then describe it afterwards. I believed Huey appeared agitated to me because he was biting his lip or pulling his hair or
cracking his knuckles, or you need to describe more than that. I appreciate that people put those things in all the time where they're actually saying those conclusions, but a proper way to do a sworn document is describe what's going on. What gave you that indication that you believed that they were agitated? We all know if you've ever, saw someone and they appear mad at you, and then you talk to them and you find out really it's something happened earlier on in the day, and that's kind of where they're kind of annoyed. So you have to be careful about putting that in a sworn document, because you don't know how that person's feeling. You want to describe what you saw, not how that person's feeling, because it's really, you can't jump to that conclusion. You're just going to describe what you saw. That was a good question.
What if a client is likely to contradict the affidavit?
So hopefully that wouldn't happen. It has happened in the past. If you're really concerned about your client contradicting the affidavit, then your real concern is your client telling the truth? Are they being consistent? That's a whole nother thing. As a lawyer, if we believe our clients aren't telling the truth, and they're switching around, we're not allowed to actually allow our clients to swear to things that aren't the truth. But a good thing to do is have them review the affidavit before they go, explain to them how serious the sworn document is before you have them swear it, explain that it's similar to giving oath in court, testimony in court. If there is something that changes, I have had clients do that. They look at it and they were wrong on a date, and they tell me, and like I said, the moment you're before that person that's reading that evidence, you're going to tell them. If the client's story changes a lot and it's not due to some kind of other issues going on, you might not want to get them to do a sworn document, but then I would say you're going to have to spend a lot of time with that client before you go to a tribunal, or before you go in some kind of mediation or hearing or anything like that. Really kind of prep to them so that they understand their story. But it's particularly concerning if your client is changing their story all the time. If it's due to some kind of disability, you can explain that to the person. That's where a sworn document might be useful, where you can say to the person, look, this person has off days and good days. Their memory was better some days and it's not other days. So the sworn document is the best evidence that we can give. So you can try to make that argument. Hope that answers the question.
I think that might be it. Oh, there. See, that happens. Oh, that answered the question.
Perfect.
So,
is there any more questions?
I don't think so. And if there are, I guess there's your email on the bottom of the PowerPoint and in the SCED. But thank you for that. It's a great PowerPoint, and I'm sure people will be wanting the copy of it because it has really useful lists and really useful guidelines. So we'll get that up on SCED as soon as we can. And thank you for your presentation, and thank you everyone for attending.
Thank you, everyone.